Municipalities.
Section 160. Municipal officers, election and term of office, officers ineligible, fiscal officers. The mayor or chief executive, police judges, members of legislative boards, or councils of towns and cities shall be elected by the qualified voters thereof. Provided, the mayor or chief executive and police judges of the towns of the 4th, 5th and 6th classes may be appointed or elected as provided by law. The terms of office of mayors or chief executives and police judges shall be 4 years, and until their successors shall be qualified, and of members of legislative boards, 2 years. When any city of the first or second class is divided into wards or districts, members of legislative boards shall be elected at large by the qualified voters of said city, but so selected that an equal proportion thereof shall reside in each of the said wards or districts. But when in any city of the first, second or third class, there are 2 legislative boards, the less numerous shall be selected from and elected by the voters at large of said city. But other officers of towns or cities shall be elected by the qualified voters therein, or appointed by the local authorities thereof, as the General Assembly may, by a general law, provide. But when elected by the voters of a town or city, their terms of office shall be 4 years, and until their successors shall be qualified. No mayor or chief executive of any city of the first or second class, after the expiration of 3 successive terms of office to which he has been elected under this Constitution, shall be eligible for the succeeding term. No fiscal officer of any city of the first or second class, after the expiration of the term of office to which he has been elected under this Constitution, shall be eligible for the succeeding term. Fiscal officer shall not include an auditor or assessor, or any other officer whose chief duty is not the collection or holding of public moneys. The General Assembly shall prescribe the qualifications of all officers of towns and cities, the manner in and causes for which they may be removed from office, and how vacancies in such offices may be filled. Section 160 provided that where there is only one legislative board of a first or second class city, members should be elected at large. This was done because the framers of the current Constitution believed that in such cities, at-large elections produced better qualified representatives. If a first or second class city has 2 boards, the less numerous of the boards should be elected at large. The chairman of the committee that drafted this provision was frank to admit that the mandatory at-large provisions were applied to larger cities only because delegates and spokespersons from the smaller cities and towns that had substantial African American populations feared that at-large elections would elect too many blacks and threaten white supremacy. Some delegates complained that Section 160 overly reflected the experiences of Louisville. In particular, they submitted that a provision that made mayors of first and second class cities ineligible for re-election after only 1 term in office was inserted in response to complaints about the incumbent mayor of Louisville, who was allegedly responsible for the city's heavy indebtedness. In 1986, the voters approved an amendment to Section 160 that enabled mayors of first and second class cities to serve 3 successive terms. Likewise, the provision making elected fiscal officers of first and second class cities ineligible for re-election was inserted in response to discovery of the embezzlement of public funds by certain financial officers of the city of Louisville. The ineligibility provision exempts auditors, assessors, and other officials who do not collect or hold public monies because the delegates believed it would be difficult to find competent auditors and assessors if they were allowed to serve only 1 term. Many of the cases under this section concern the constitutionality of the appointment and removal provisions. The Kentucky Court of Appeals held that Section 160, which provides that other officers of towns and cities shall be elected or appointed by local authorities, invalidates that part of a statute that vested the appointment of the alcohol administration of the City of Louisville in the State Department of Revenue, in Chandler v. City of Louisville, 1939. The court also held that Section 160 authorizes the General Assembly to provide for removal of a city marshal without cause before his or her term expires, in London v. City of Franklin, 1904. However, the power conferred on the General Assembly by this section to prescribe the manner of filling vacancies in municipal offices does not include the power to extend the term of appointees, which is fixed by Section 152, in Scott v. Singleton, 1916. The Attorney General ruled that where the General Assembly has failed to provide for the removal of the officers of cities of the 4th class, the only method to remove such officers is by the impeachment process.
Section 161. Compensation of city, county, or municipal officer not to be changed after election or appointment or during term, nor term extended. The compensation of any city, county, town or municipal officer shall not be changed after his election or appointment, or during his term of office, nor shall the term of any such officer be extended beyond the period for which he may have been elected or appointed. The framers of the current Constitution added this section, not found in previous constitutions, to prohibit the practice of municipal officials securing from the General Assembly, by special legislation, extensions of their terms, increases of their salaries, or both, after they had been elected to office. The Kentucky judiciary has ruled that Section 161 applies to constitutional officers only, in Graves County Board of Education v. DeWeese, 1960, and does not apply to municipal officers such as a revenue agent who may be discharged at the pleasure of their appointing body, in Commonwealth v. Ewald Iron Company, 1913. Compensation for such officers cannot be changed during their terms of office unless their official duties are changed. In Hobson v. Revenue Department, 1944. The General Assembly cannot constitutionally increase sheriff's commissions for collecting taxes during their terms of office since this would represent an invalid increase in compensation, in Weber v. True, 1947, nor can a county court disguise a salary increase as an allowance for traveling expenses, in Estill County v. Noland, 1945. However, a county attorney is entitled to receive compensation from the county, in addition to his or her regular salary, for services performed outside of, and independent of, official duties, in Slayton v. Rogers, 1908.
Section 162. Unauthorized contracts of cities, counties, and municipalities are void. No county, city, town, or other municipality shall ever be authorized or permitted to pay any claim created against it, under any agreement or contract made without express authority of law, and all such unauthorized agreements or contracts shall be null and void. During the period of the Third Constitution, officials of local government, and especially of cities, not infrequently made unauthorized contracts in behalf of their governments, which the latter would then usually, albeit grudgingly, ratify. Louisville seems to have been particularly plagued by these agreements, in an amount in excess of $1 million, according to a delegate from that city. Such contracts gave rise to excessive, even unnecessary spending. The framers of the current Constitution added Section 162 to curtail such activity, specifying, not only that such contracts shall be null and void, but that claims against the local government based upon such agreements shall never be paid. The Kentucky Court of Appeals has held that Section 162 prevents school boards from paying claims under agreements made without express authority of the law. Such as a bonus to a contractor for the speedy construction of a school building, in Catterjohn v. Paducah Board of Education, 1923. This section also prevents a second-class city from issuing bonds for the construction of a memorial building, since the city has no express authority for such construction, in Barrow v. Bradley, 1921. However, a statute that provides for the holding of a circuit court in towns other than county seats and specifies that such towns shall bear the expense of building a courtroom and jail constitutes sufficient authority under Section 162 for the construction of these facilities, in Johnson v. City of Fulton, 1905.
Section 163. Public utilities must obtain franchise to use streets. No street railway, gas, water, steam heating, telephone, or electric light company, within a city or town, shall be permitted or authorized to construct its tracks, lay its pipes or mains, or erect its poles, posts, or other apparatus along, over, under or across the streets, alleys or public grounds of a city or town, without the consent of the proper legislative bodies or boards of such city or town being first obtained. But when charters have been heretofore granted conferring such rights, and work has in good faith been begun thereunder, the provisions of this section shall not apply. The experience of Louisville figured prominently in the insertion of this section into the Constitution. According to the chairman, who was from Louisville, of the committee that drafted Section 163, a street railway company obtained from the General Assembly a charter that permitted it to build a railway in Louisville without the permission of the government of that city. The city sued to prevent construction of the railway, but the judiciary ruled in favor of the company, which later sold the franchise for a great profit. Section 163 places the authority to award utilities franchises within cities to the governments of those cities, the only exception being for utility companies that had been granted legislative franchises before the Constitution went into effect and had in good faith begun work under those charters. The Kentucky judiciary has ruled that under Section 163, a city has the right of final decision as to whether a public utility may use or occupy the city street, in Whitaker v. Louisville Transit Company, 1955. Section 163 likewise prevents the General Assembly from taking from a city the right to require electric utilities to place their wires underground, and thus the transfer of that power to the Public Service Commission is unconstitutional, in Benzinger v. Union Light Heat and Power Company, 1943. The Kentucky Supreme Court has ruled that Section 163 does not authorize a city to force a utility to remove equipment that was in place before the city annexed the area in question, in City of Florence v. Owen Electric Cooperative Incorporated, 1992. Similarly, the judiciary held that Section 163 does not prohibit the legislature from giving the Public Utilities Commission the right to fix the rates of utilities, even if such rates were before set by the municipalities in which the utilities operated, in Southern Bell Telephone and Telegraph Company v. City of Louisville, 1936.
Section 164. Term of franchises limited, advertisement and bids. No county, city, town, taxing district or other municipality shall be authorized or permitted to grant any franchise or privilege or make any contract in reference thereto for a term exceeding 20 years. Before granting such franchise or privilege for a term of years, such municipality shall first, after due advertisement, receive bids therefor publicly, and award the same to the highest and best bidder. But it shall have the right to reject any or all bids. This section shall not apply to a trunk railway. The experience of Louisville likewise influenced the decision to insert this section into the Constitution. The chairman of the committee that drafted Section 164 asserted that owners of street railway companies operating in Louisville had persuaded the city council, shortly before their franchises were to expire and ownership of the companies reverted to the city, to extend the life of the franchises, which were shortly thereafter sold to Eastern interests for a substantial price. Furthermore, the city received almost nothing for granting a franchise to an electric utility company worth millions of dollars. To prevent these outrages and others that allegedly plagued Kentucky's cities and towns in general, Section 164 requires local governments to advertise available franchises, receive bids for them, and limit them to a term not exceeding 20 years. The Kentucky judiciary has ruled that Section 164 does not prohibit a city from granting a 40-year lease, with an option to terminate it upon a 1 year's notice, and to purchase the improvements, in Dieters v. City of Louisville, 1952. Section 164 also allows a city and a streetcar company to amend the franchise agreement and substitute buses for streetcars, in Russell v. Kentucky Utilities Company, 1929. Cities also may award a cable franchise to a lower bidder if the decision represents the exercise of sound discretion and is untainted by arbitrariness or corruption, in Communications Systems Incorporated v. City of Danville, 1989. However, a city may not, under Section 164, allow bidders for a franchise to alter in their bids the terms of the advertisement. In Owensboro Grain Company v. Owensboro Riverport Authority, 1991. A person who performs services for a city under a franchise agreement must ensure that the city official with whom he or she contracts has the authority to do so, for if no such authority exists, the contract is void under Section 164, and the city is not liable for the services rendered, in Worrell Manufacturing Company v. Ashland, 1914. The U.S. Supreme Court held that Section 164 did not revoke a right acquired by a telephone company during the period of the previous Constitution to use the streets of Louisville for telephone purposes, nor did it give the City Council the authority to revoke that right, in City of Louisville v. Cumberland Telephone Telegraph Company. 1912.
Section 165. Incompatible offices and employments. No person shall, at the same time, be a state officer or a deputy officer or member of the General Assembly, and an officer of any county, city, town, or other municipality, or an employee thereof, and no person shall, at the same time, fill 2 municipal offices either in the same or different municipalities, except as may be otherwise provided in this Constitution, but a notary public, or an officer of the militia, shall not be ineligible to hold any other office mentioned in this section. Despite the declaration of the chairman of the committee that proposed this section that an identical provision could be found in the Third Constitution, no such section existed in any previous state constitution. Nor do the published debates of the Constitutional Convention of 1890 to 1891 furnish any evidence as to why this section was inserted in the current Constitution, although, presumably, the framers wished to prevent divided loyalties, conflicts of interest, and multiplicity of office holdings. Section 165 prohibits the simultaneous holding of an office in state government, including membership in the legislature, and an office or employment in county or municipal government, or the simultaneous holding of more than one municipal office. Virtually all of the opinions about this section deal with the question of whether a governmental office lies within the scope of the section. Thus, a public school principal can simultaneously serve as a state legislator, in Board of Trustees of Fairview Graded Common School District vs. Renfro, 1935, a state employee can also serve on a local school board, and a highway maintenance supervisor can also hold state office, in Pauley vs. Fortenberry, 1937. However, a member of a county board of education cannot also serve as county election commissioner. In Adams v. Commonwealth, 1954, a deputy sheriff cannot simultaneously serve as a city tax collector. In Keating v. City of Covington, 1896, and a person cannot be a district judge and a master commissioner at the same time.
Section 166. Expiration of city charters granted prior to Constitution. All acts of incorporation of cities and towns heretofore granted, and all amendments thereto, except as provided in Section 167, shall continue in force under this Constitution, and all city and police courts established in any city or town shall remain, with their present powers and jurisdictions, until such time as the General Assembly shall provide by general laws for the government of towns and cities, and the officers and courts thereof. But not longer than 4 years from and after the 1st day of January, 1891, within which time the General Assembly shall provide by general laws for the government of towns and cities, and the officers and courts thereof, as provided in this Constitution. This section, which is newly added to this Constitution, is in keeping with the intent of the framers to eliminate the disparity between municipal charters, all of which had been created by special legislation, and to establish uniform powers among the classes of cities. The General Assembly, as mandated by Section 166, had enacted by March 1894 a general law of government for each of the 6 classes of cities created by Section 156. In one of the few cases concerning Section 166, the Kentucky Court of Appeals held in City of Mayfield v. Elmore, in 1897, that the section did not prohibit the General Assembly from amending a city charter within the 4-year period during which the existing municipal charters remained in force. The court also held that Section 166 repealed by implication all municipal charters granted by special legislation before 1891, and therefore a fired city engineer could not claim the right to office under such a charter, in Parsons v. Breed, 1907. The Special Commission on Constitutional Review of 1987 recommended the repeal of Section 166 because it is obsolete.
Section 167. Time of election of city, urban county, and town officers. All officers required to be elected in cities, urban counties, and towns by this Constitution, or by general laws enacted in conformity to its provisions, shall be elected at the general elections in November in even-numbered years. This section was changed in 1992 as a part of an omnibus amendment that provided for the election of all but statewide officers in even-numbered years. In the opinion of the Attorney General, Section 167 as amended prohibits cities from holding staggered elections.
Section 168. Ordinance not to fix less penalty than statute for same offense, prosecution under 1 a bar. No municipal ordinance shall fix a penalty for a violation thereof at less than that imposed by statute for the same offense. A conviction or acquittal under either shall constitute a bar to another prosecution for the same offense. During the period of the Third Constitution, the Kentucky Court of Appeals held that it was constitutional to punish a person twice for the same act, one time as a violation of a municipal ordinance and another time as a violation of a state statute, in Kemper v. Commonwealth, 1887. This section is designed to prohibit what the framers of the current Constitution regarded as double jeopardy. Another objective was to prevent a municipality from penalizing the same crime less severely than a state statute, as was sometimes the case before the adoption of the current constitution. In Murphy v. City of Lake Louis Villa, in 1957, the Court of Appeals ruled that a municipality may not fix a penalty for a traffic violation that is less than that imposed by state statute. A person convicted of violating a municipal ordinance against gaming cannot be prosecuted for violating a state statute prohibiting the same conduct, in White v. Commonwealth, 1906. However, a conviction under an ordinance for an offense that is not a statutory, but rather a common law offense, such as nuisance, does not bar a conviction for the same offense in the circuit court pursuant to a prosecution by the state, in Respis v. Commonwealth, 1899.
Thank you for viewing this history of the Kentucky Constitution. For more information, please see the following references. Citizen's Guide to the Kentucky Constitution by the Legislative Research Commission, available online. Or the book, The Kentucky State Constitution, by Robert M. Ireland, Oxford University Press.